Thank you for joining us for the webinar today. My name is Joan Popolo. I'm Director at Action Innovation Network. And for those of you who don't know who we are, Action is a collaborative network of technology business incubators and other entrepreneur support organizations. And they're based throughout the Boston, Greater Boston, and New England region. Our network supports startups developing technologies in the industry sectors of the life sciences, clean tech, robotics, advanced materials, and ocean and maritime. We provide a suite of resources for international startups that are looking to explore the Boston innovation ecosystem as a place to grow their company in the US. I'm going to go over a couple of small housekeeping items for the organization of this webinar today. As the attendees come in, they will all be muted, both audio and video. The presentation will run for about 45 minutes, leaving about 15 minutes in the end for any of your questions and answers. We do have a method for you to type in the chat box your questions, which will be all answered at the end of the presentation. The webinar will be recorded and posted on the Action website for your future viewing if you want to listen to it again or look at the slides. So today's webinar, Doing Business in the U.S., an overview of corporations and limited liability companies, will be presented by Timothy Monahan, who's an associate at the law firm of Bowditch & Dewey. A little bit about Tim. He represents lenders and borrowers in all types of financing transactions, including asset-based financing, real estate financing, general commercial financing, construction financing, issuance of credit enhancements and bond transactions, participations, and intercreditor transactions. He also advises clients in the merging, acquisition, and sale of businesses, the formation of various entities, the structuring and negotiation of joint ventures, and other general business contracts, such as loan documents. Additionally, Tim counsels businesses regarding regulatory compliance, contract interpretation, and securities filings. So with that, I'm going to let Tim begin the presentation.
Okay, great. Joan, thank you very much. Good morning, everybody. My name is Tim Monahan. As Joan mentioned, I'm an attorney here at Bowditch & Dewey in Worcester, Massachusetts. A little bit about the firm. We've been around for 150 years. I've been practicing for about 10 of that. I'm in the business and finance group here. I split my time between, as Joan mentioned, some corporate work and some finance work. And I'm looking forward to getting into the presentation. So what we're going to talk about today is doing business in the United States, and some issues regarding corporations and LLCs and other entities that you might consider but will likely not opt for, but we're going to mention those as well. I think the purpose of today, we're going to try to get into, the hope is that by the end of this, you're going to have an understanding of sort of the different options that you have in regard to corporate entities, some of the benefits and drawbacks of each. We're going to review the steps in the formation of a corporation, of corporations and LLCs in the United States. We're going to review and talk about some key terms that you might consider when you are drafting your bylaws and your operating agreements, bylaws for your corps, operating agreements for your LLCs. We're also going to touch on some other key business considerations that it's helpful for new business owners to simply be aware of as they are forming their entities and, frankly, when they're getting their businesses up and running. So we'll touch on and review some issues regarding contracts, litigation, and certain regulatory compliance, which is not going to be the same in the United States as it might be where you, the viewer, are from. So it's my understanding that we do have something of an international audience. So I'm going to try to keep this presentation as general as possible so that it is accessible to everybody. If there are more specific questions, I will certainly be happy to address those as they come up, or at the end of the presentation, as Joan mentioned. Feel free to type any sort of message through while I'm giving the presentation. And if I can answer it at the time, I'd be happy to do so. So, okay, let's get into the presentation. All right, so entity formation considerations and importance. So the thing that I like so much about working with entrepreneurs is that you guys are doers. You have a great idea, you're excited about it, you have this energy, you really want to get your business up and running. And sometimes in that excitement, certain things get lost and overlooked. And while you can always work out those problems later on, it's helpful to take a moment, a few days maybe, to carefully consider what you're trying to accomplish and what entity form might best help you accomplish that. So, are you looking to, the main purpose to forming these entities is obviously to reduce personal exposure to and limit your own personal liability. The entities that we cover today are going to both be able to accomplish that. But depending on what your goals are for the business, whether you're going to grow it into something large that's eventually going to go public or be sold, or you're going to start bringing revenue immediately and you want to access that revenue, it could have implications on the types of taxes that you have to pay. The common considerations between corporations and LLCs and corporate C corps and S corps is the idea of double taxation, and the other sort of tax consideration, they're not the only one, but certainly one of them, is to convert your current income into a long-term capital gain, which is a lower tax rate typically than your corporate taxes. The other consideration, you want to make sure that you are thinking of, am I launching my business into a form that is capable in being financed the way that I think I'm going to be financed? So if you're, am I going to bootstrap? Then obviously that bootstrap your business, obviously it's, the form of the entity is going to be less important. But if you're going to raise funds from venture capital folks, or you're going to receive a bank financing of some sort, it's going to make a difference sort of what form or what entity ultimately you decide to use. And the last part of this, and I think a key part, which is often overlooked, is the formation of the entity, and in particular the drafting of the operating agreement for an LLC or the bylaws of a corporation, is an opportunity for you, and if you have co-founders, to sit down and have some what can be difficult or awkward conversations, but really important conversations for you to have in terms of who owns what voting rights everyone's going to have, what the expectations are for what people are going to do in the business. It's sort of a point where you can really force these conversations to take place, and they really are key conversations, because while you can work these things out later on, it's always best to have everybody going in on the same page. Okay, so there are certain types of entities that we're going to run through briefly today. Corporations, C corps and S corps, limited liability companies, I'm sure you're familiar with at least the terms there, partnerships, unincorporated sole proprietorships. I'm going to skip down to the bottom one and run through it very quickly right now. Hopefully by the time we are done with this presentation, you'll say that this is not the way I'm going to run and form my business. Basically, an unincorporated entity, if you are unincorporated, if you're a sole proprietorship, you have no liability or asset protection. You and your business are the same person. Remember that famous quote by Mitt Romney, corporations are people. Well, in this case, you and your business are in fact the same person. You don't have that separate person, corporate entity, to help provide that limitation of liability. So hopefully, and if I were better at PowerPoint right now, I would be pressing a button and unincorporated sole proprietorships would be being crossed off on your screen. But unfortunately for both of us, or all of us, I am frankly not that talented at it, so you're gonna have to take my word for it that I am crossing that off on my paper presentation right now, and I think you should do the same. Partnerships we can also cover briefly. These are not. It's a separate entity for some partnerships are separate entities for some purposes and not for other purposes. You don't pay taxes on the total activities of the partnership. Each partner is responsible for their own percent of the profits, depending on the amount of the partnership that they own. It's not something. It is not a popular entity to form amongst the people that we are working with in terms of startups, and really the only place you see them are places like law firms, sometimes medical practices, but even those these days are trending more towards professional limited liability companies, which you can open here in Massachusetts and sort of throughout New England, and I imagine across the country as well. So you can have a limited liability partnership if you pay $500 a year to the Secretary of State, but again, it's not a corporate form that I think is popular, and I think the reason for that is because it's sort of been replaced by the LLC, which is a pretty popular entity type and provides a lot of the same functionality without some of the problematic aspects of it. So I'm not going to cross off partnerships because I think they are still viable for some purposes, but we are not going to talk about them anymore. We're going to move on to corporations, C corps, and S corps, and limited liability companies, because I think really that's what I imagine the folks watching this would like to hear. And I think, frankly, that's when we are representing clients, that's typically where we recommend they go when they're looking to form their companies. All right, so corporations, you've heard me mention a couple different times, C corps and S corps. Basically, the distinction between the two is really for taxation purposes and some shareholder eligibility requirements. So C corps are taxed at both the corporate level, which I'm going to call, and you'll see on your screen, is quote the first level of taxation. You'll hear this a lot. I think 2 levels of taxation when it comes to corporations. So any income that comes into the corporation is taxed as corporate income at the corporate tax rate, and then when you pay out salaries or dividends, that money is going to be taxed again. So if you are the owner of the corporation, you're getting taxed both at the corporate level and then again when you receive your salary, and people refer to that as double taxation, and it's a problem that you can avoid by structuring your company as an S corp or an LLC, but it's something that you're going to have to deal with if you do decide to form a corporation. So a C corp, I should say. So an S corp, the benefit really is that it allows this quote pass-through taxation. So basically, the income of the corporation passes through directly to the stockholders, the owners of the company, who then account for that income on their own personal tax returns. So you have the corporate entities in existence, you get that liability protection, but you do get the benefit of having taxes pass through directly to your stockholders. So if you're going to make and this is sort of mechanical, but if you're going to make the creation of the 2 corporations done in a similar fashion, the one difference is going to be that if you are creating or would like to create an S corp, you're going to have to make your initial S election with the IRS within 15 days of the 3rd month of your existence in the business, in order to qualify and get that pass-through taxation treatment. If you choose initially to form an S corp or a C corp, you can convert from one to the other. S corps you can convert anytime by filing documents with the IRS. If you want the taxes to be treated for the whole fiscal year of the business, you have to make the if you're converting to the C corp, you would have to revoke your S election within 15 days of the beginning of the business's tax year. If you're going to convert from a C Corp to an S Corp, the IRS will only allow that to take place within the first 15 days of your tax year, and you file form, if you'd like to know, file form 2553 with the IRS in order to make that conversion. But again, it's got to be done at the first 15 days of the tax year if you're going to go from a C Corp to an S Corp. But there is some flexibility to move between the two. All right, so we can talk about C Corps and when to consider them, when they might be appropriate. So if you are thinking, I mean, obviously everybody wants to build value in their business, but if you're thinking long-term, if you're thinking that the payout from your starting this business is going to happen in the long term, so you want to build long-term value, the C Corp is an entity that allows you to invest profits back into the corporation. So you're taxed at the corporate level for the income that comes in, but you don't have to pay that out in salaries or dividends. I mean, money can be held at the corporate level and reinvested. You can you can invest in whatever assets you think you'll need for the company to grow. You can buy real estate. You can do any number of things that you think will help. I mean, invest in R&D if you're tech or medical device or what have you. If you're in an R&D heavy field, you can put that money directly back into the business and not be taxed at that second level. So if you're looking to grow sort of long-term value, if that's the goal, the C Corp might be a good option. So that's one factor to consider. If the goal ultimately, again, this kind of goes hand in hand with developing long-term value. If the goal is to ultimately go public and be a publicly traded company, a C Corp provides the recognized corporate structure that investors like to see. The corporate governance structure would be board of directors, overseeing officers who are running the company on a day-to-day basis, and obviously stockholders are the actual quote-unquote owners of the company. C Corps provide the ability to both create an unlimited amount of shares and the easy transfer of those shares. And a key distinction between a C Corp and an S Corp is that there's no limit as to how many or the type of stockholders that you can have. In an S Corp, as you'll see in the next slide, there's certain limitations on the number of stockholders, which can be limiting as you're trying to grow your business, and there's certain limitations in what types of entities can actually own S Corp stock. Another sort of factor to consider is the funding strategy. And again, I say this, I'm going to say this, I'm not a venture capitalist. I've worked with some VCs in the past, certainly. And this is sort of the generic advice, but it is what's out there, and it's something that you should consider, because I think it is sort of the quote unquote rule of thumb, but it is not by any means intended to say you can't get VC money if you're not a C Corp. But the general sense is that that VCs prefer a C Corp because many VCs sort of raise money from tax-exempt entities, pension and profit-sharing trusts, and universities. And if those tax-exempt entities would receive taxable unrelated business income if the VC invested in a flow-through entity like an S Corp or an LLC. So there are reasons that VCs prefer, I mean, in addition to the reason we just mentioned, the sort of familiar corporate governance structure, that theoretically VCs prefer that, but again, it's the general consensus, but it is not certainly true in every case. Finally, compensation strategy. One thing that the corporation has going for it are some of the ways that you can compensate and retain talent. I mean, obviously it's one of the important considerations for a startup. How are you might not have much cash flow. How are you going to bring people into your company? How are you going to keep them there? And one way you can do that is through setting up sort of a stock ownership or stock plan that allows employees to earn and have stock vest over the course of their service to the company. So corporations can have different classes of stock, which is helpful because you can have you can give common stock to your managers or to your employees, and preferred stock to your big money investors. So it allows you to differentiate between the two, but still reward the employees who you're going to need to help build your company, while enticing investors to provide the necessary funds again to help grow your business. Another positive, so U.S. tax, I'm going to skip the second bullet and move down to the third, but U.S. tax law allows for incentive stock options, which again is a great way to retain. It's a really wonderful benefit for employees. They're able to earn stock options, they're able to have those stock options vest, and they are only taxed when those options are actually sold. So again, wonderful benefit to employees. And then finally, again, sort of a generic thought that, which is true because people are more familiar with stock than, say, membership interest of an LLC, but the idea that in order to help retain talent, your employees, if you were explaining to them what you were offering them, it's just easier to understand stock ownership versus membership interest ownership. So again, it might depend on the level of sophistication of the employee, but again, generally, I would say true and probably a benefit of the corporation, the C corporation structure, I should say. All right, S corps. So again, you have that still the same traditional corporate structure, the board or overseeing the officers and stockholders owning the company. It allows you, as we've mentioned, to make use of that pass-through taxation, so you can avoid that second level of taxation as you're doing business. But one of the key differences, and while the avoiding the second level of taxation is certainly a benefit, there's certainly some drawbacks because there are limitations as to the number of stockholders you can have, who can own stock. So let's see, the stockholders are limited to 100 or fewer stockholders, which in a lot of ways makes sense because in order to make the initial S election, you have to have the sign off of all of your stockholders. So if you have more than 100, I think it's sort of unwieldy, and it'll be like wrangling cats to get their consent to make that actual S election, or the initial S election anyway. So you're limited to 100 stockholders. The corporation must be a domestic corporation, meaning a corporation formed in one of the states of the United States. Shareholders must be U.S. citizens or legal residents. Shareholders can't be partnerships, corporations, insurance companies, or banks. You have to adopt a certain tax year. And as I mentioned, each stockholder must consent to the S election, which, as I said, as the number of stockholders grows, becomes increasingly more difficult. All right, so the actual mechanism, I'm going to skip to the next slide. So the actual mechanism of forming a corporation in the United States. So something to keep in mind, corporations are entities that are formed at the state level. So again, in New England, for purposes of this program, certainly Massachusetts, New Hampshire, Vermont, Connecticut, Maine, Rhode Island, you can form a corporation in any of them. That corporation will exist in that state and it can do business throughout the country. However, you will have to, in all likelihood, file or qualify to do business in other jurisdictions. So if you have a Massachusetts corporation and you're going to also do business in New Hampshire and Vermont, in all likelihood, you're going to have to file on an annual basis to qualify to do business in those states. I will point out here that another state that is very popular to form an entity in is in Delaware, and we see it pretty frequently. People forming Delaware entities because they've heard of Delaware's robust corporate law and they think that that's what they're supposed to do. And there's some benefit certainly to that corporate law, and there's some benefit to forming in Delaware. However, one common complaint that we do see from folks who form in Delaware and technically Delaware corporations, but do business in New England or Massachusetts, New Hampshire in particular, is that they're stuck paying both a Delaware annual costs related to Delaware and then annual costs related to Massachusetts, and they're not really sure what benefit they're receiving. So it's just something to keep in mind that the general advice of a Delaware corporation or a Delaware LLC is the way to go. Is not necessarily the case for all companies. And in a lot of cases, I think you're better forming your company where you're going to initially do business. We see a lot of successful companies formed in Massachusetts who form Massachusetts entities and go on to great success and work in and throughout other states of the country and without any drawback. So, and you're only paying the annual cost of Massachusetts or one of the other states that you're formed in. So mechanically, before you go to file your documents with the secretary of whatever state you are filing in Massachusetts, you do the Secretary of the Commonwealth, you can do a name search to make sure the name that you want is available. Apparently, I was thinking of Thanksgiving over the weekend as I was thinking of the these potential similarity between names. So basically, two corporations aren't going to be allowed to have names which are overly similar. It's going to be at some extent the discretion of the Secretary of the Commonwealth or the Secretary of whatever state you're filing in. But yeah, Turkey Inc. and Turkey One Inc. It might be a little touch and go if there's already a Turkey Inc. You might not be able to file your Turkey One Inc. as a corporation. But you can conduct these searches. You can then reserve names to make sure that they're available for when you actually file. So actually forming the entity, you would have an action by a sole incorporator generally. That sole incorporator would then authorize the formation of the filing of the articles of incorporation with the Secretary of the state of whatever you're filing in. In this case, we'll say Massachusetts. I would appoint your initial board of directors. The board of directors would then take action, usually by again, unanimous written consent, to issue stock, elect the first officers, authorize payment of incorporation expenses, obtain your EIN number, which is the tax ID number from the IRS, and establish a bank account. And if you're going to make that S election and become an S Corp, the board of directors would authorize that as well. You'll also need to appoint a registered agent, but that's done when you're filing your article of incorporation. And the registered agent is an interesting role, but basically what the registered agent does is provide somebody who is local in the jurisdiction who can be served with process or served with the paperwork for a lawsuit. And again, if you were to file in Delaware, you would have to maintain a registered agent both in Delaware as well, which is another expense that startups frequently sort of regret having to pay on an annual basis. So in order to file in Massachusetts, you're filing in these are all more or less the same documents that you're going to file, but the documents filed with each state have different names, even though they do the same thing. So in Massachusetts, you're filing articles of organization. New Hampshire, Maine, Vermont, Rhode Island, articles of incorporation, and certificates of incorporation in Connecticut. Just more or less different names for the same document, but it does sort of underscore the fact that there are different corporate laws in each jurisdiction, and it's something that you want to, if you're going to file in one place over another, you should probably familiarize yourself with the terminology and the underlying law in that jurisdiction. So limited liability companies, like corporations, limited liability companies are distinct entities which can offer perpetual existence. Again, like corporations, I will note that Massachusetts by statute in their LLC statute provides for certain events of dissolution, which can result in death or retirement of a member, which, unless you deal with it properly in the operating agreement, can result in the automatic dissolution of that entity. But again, as long as you deal with it in your operating agreement, you can have that perpetual existence like you can in a corporation. Again, limited liability companies offer that liability protection from its members. And I should point out that while you are always responsible for your own negligence, the liability that you're being protected from is really if if somebody related to the company does something negligent, that somebody who's filing a lawsuit against you cannot, without piercing the veil, which we'll get to later on, cannot look to your personal assets to satisfy any judgment that they obtain. They can only look to the assets of the company. LLCs, like S corps, allow you to avoid that second level of taxation, so it's a pass-through entity, which again, so the funds that flow in are going to be accounted for on your personal income taxes at the time that you file them. Each member would be given a K-1 for their different for the taxes for which they're going to be responsible for, or the income they're going to be responsible for paying taxes on. The benefit of the LLC is this increased flexibility. So there's no limit in the number of type of equity holders like in an S corp. So they both give that same pass-through treatment. You don't have to have this typical corporate structure of a board and officers running the company, though you can have a board of managers and you can appoint officers. You can also have member-managed LLCs, which is essentially the owners of the company, the members running the company on a day-to-day basis. More commonly, I think we see manager-managed. Excuse me. And frequently, we will see a structure that is set up to sort of emulate that corporate structure with a board of managers and officers being appointed to run on a day-to-day. And I will say the one additional point to note is that in terms of distribution of profits, so you can own an LLC on a 50-50 basis, but the flexibility of the LLC allows you to split profits on a different percentage if that is something that is of interest to the people running it. If one party happens to be doing more work or is more involved, you can agree among the members to make a different distribution or make a distribution of profits that's different than what your distribution of ownership actually is, which is kind of a neat function for the LLC. Let's see. LLC formation, it is simpler than forming a corporation. You don't have to have the independent incorporator. Basically, you conduct your name search, you find your preferred name. You can reserve it for a small fee. You would file in Massachusetts your certificate of formation with the Office of the Secretary of the Commonwealth. And obviously, throughout New England, you would file it at whatever Secretary's office for the state that you're forming. In terms of fees, the difference between filing a corporation and filing an LLC, there is an increase for filing an LLC. It's a $500 filing fee. I think it gets up to $523.50 or something like that if you file online, which is the way most people do, for the $23.50 being a convenience charge. But you file for $500 a year. You're going to have to do annual maintenance filing an annual report. Excuse me, you know what? I'm sorry, I didn't forward to the next slide. So there you go. As I mentioned, the name search, filing the LLC, it's going to be certificate of formation for $500. You're going to need to appoint a registered agent again for that particular jurisdiction. And again, so that's just somebody who can receive service of process in the event that the company gets sued. Your annual maintenance, you're going to have to file annual reports with the Secretary's office in whatever state you are registered to do business in. So that will be your home state. And in Massachusetts, again, the $500 fee. And it could be the other states in which you're doing business. So if you own real estate, if your company is a Massachusetts LLC that owns real estate in, say, New Hampshire, you're likely having to qualify to do business in New Hampshire, and what might entail a fee there. If you have just a salesperson in another state, it might be a closer call if you don't own real estate, but that's something to just keep in mind. Okay, so the key document that you're going to put together, and this is the moment to have a discussion with your co-founders. The key documents that you're putting together for corporations are going to be your bylaws. For LLCs, it's going to be your operating agreement. So again, as I mentioned, this is an opportunity to set expectations and to sort of manage everybody's understanding. But who is going to, it's also along with that. So you're going to have these discussions about who has what voting power, who can appoint who to the board of directors. I mean, frequently you'll see board of directors appointed by the stockholders by a majority vote, but that's not always the case. It could be a 2/3 majority. It could be, that certain stockholders have the ability to appoint a certain number of directors. But all of these things are issues that can come up when discussing the operating agreement or your bylaws. Other sort of key provisions that you might see in these documents, I think are necessary. I think I'll run through them really quickly, but rights of first refusal. If a stockholder is going to sell, or if a member is going to sell, the other members want the right, or in all likelihood will want the right to buy those shares or membership interests, so they're not being sold to a third party, so you're not stuck with sort of a stranger who is now involved in your business. Call options or put options. Call options provide the right to buy, the right for a majority shareholder to buy at a certain price. Put options provide the right to sell options at a certain price. And again, these are prices that are agreed upon. It's negotiated into the operating agreement, and it provides hopefully people will have a better understanding about what their rights are in the corporation. There are also tag along and drag along rights, and this is the idea that if a majority shareholder or a majority member goes tag along, as if a majority shareholder is going to sell, it allows a minority shareholder to join that transaction and gives them the same right to sell their shares for the same price that were negotiated by the majority shareholder. Drag along rights, conversely, are the idea that a majority shareholder can force a minority shareholder to sell their shares along with the majority shares. So if the majority shareholder wants to sell the business, it can, if this provision is in the operating agreement or the bylaws, can force a minority shareholder to sell the shares. Again, these are provisions that are not in every operating agreement, but it's ones you want to look out for, certainly as you're reviewing it, and ones you want to consider as you are drafting, because frankly, if you're going to be a majority shareholder, in all likelihood, you want to have that control to force a minority shareholders to sell. And if you are a minority shareholder, you want to be able to join a sale if a majority shareholder is selling. So important provisions to have in there. And a couple points I will make, further points I'll make on this slide. If you are forming another business with another person, or if you're forming a business with another person, a frequent sort of hedge that people make in case of basically death or disability, but death in this case is purchase of life insurance, cross life insurance, so that if your partner dies or if the other stockholder dies or member dies, they will have the liquidity to buy out the family member. So you again are not stuck running a business with someone you never intended to run a business with. So we're getting up there in time. So we'll go through the next few slides pretty quickly, so we can hopefully have some time for questions. But this is limitations of limited liability. Basically, as I said, you're always responsible for your own negligence, but there are situations where the quote, the protection offered by these entities, corporations and LLCs, can be pierced, and you can be personally liable. In order to avoid this, I mean, your best practices are you maintain corporate formalities by holding annual meetings and conducting your business in accordance with the operating agreement. I think the biggest one of these is to make sure that your business is properly capitalized. If the business is a shell which holds nothing, it increases the likelihood a great deal that if you are sued, a court will allow a litigant to get through the corporate entity and pursue you individually. You want to make sure that you do your annual maintenance, file your annual reports, And also importantly, segregate corporate or company finances from your own finances. Another big one, if you're intermingling funds, the intermingled funds begin to look a lot more like property of the company than it does to as personal funds. So bottom line is, I think you want to treat this company as what it is, which is a separate person, a separate entity with its own bank accounts and its own rules. In order to do anything, if the bylaws say that you have to get stockholder approval to take out a loan of $100,000 or more, then you have to get stockholder approval. You take the vote and you make sure you do that business in accordance with the governing documents, the bylaws, or the operating agreements. Regulatory compliance, I would even just take a look at this and come back to it when you have some time. But basically, there are certain programs that if you open in New England that you're going to have to make sure that you're properly registered, properly contributing to. Your workers' compensation. If you hire a good payroll company, I think this makes this job a lot easier. And depending on the size of your company, you might have to make sure you're in compliance with the Family Medical Leave Act, Equal Opportunity Commission, or ADA compliance. Again, which family medical leave, 50 employers or more, affirmative action compliance, 50 employees or more, or $50,000 in government contracts. ADA is only 15 employees. You are required to comply with the Americans with Disabilities Act if you have 15 employees. Or age discrimination is, again, another pretty low hurdle of 20 employees. Your financing considerations, we touched on this a little bit. It could impact what sort of entity you form. Obviously, you want to, one of the most precious as a startup company, one of the most precious resources you have is your equity, and you want to guard it carefully. So obviously, the more you can bootstrap these funds, the better off you will likely be. If you are going to look at getting, VC funding, I think the calculation you want to make is, am I giving up equity? Is the money that I'm getting in and the equity I'm giving up going to result in making the shares that I currently hold more valuable in the long term? Commercial loans are great if you can get them, but they are difficult. You do need to have assets to put up as collateral in order to obtain a loan from a bank. You certainly want to be wary of personal guarantees if you're entering into a commercial loan or signing a lease or what have you, because it does help circumvent all the hard work you did for of creating these entities. It gives a landlord or a bank, recourse against your personal assets. Okay. And this is really just some commercial contracts you might run into as you open your business. Say leases are certainly most common as you're opening and looking for space, but also customer agreements, vendor agreements, license agreements, and employee agreements all have their own pitfalls, and it is good to have experienced counsel help walk you through that to the extent possible to make sure that you are protecting your company. And business litigation, again, is it is a fact of life that if you are doing anything in this world, you run the risk of being sued, and it is no different starting your own business. Business litigation. So again, you can work to minimize your risk by making sure that you're properly covered by insurance. But ultimately, getting sued is not a choice, and if you do get sued, you should reach out to competent counsel to help you walk you through whether it's mediation or arbitration or actually pursuing a lawsuit in the court with appropriate jurisdiction. So again, I apologize for rushing through those last slides, but I wanted to make sure that we had some time left in case there were any questions, or if anybody wanted to get into something in a little bit more detail.
Thank you very much, Tim. There's a lot of information there, and hopefully people will review it once again to get into some of those details. There are a couple of questions that have come from the audience. And the first one is, are there any particular provisions for stocks if employees are foreigners?
Well, I mean, for one provision that sort of jumps to mind, which I mentioned, is the limitations regarding the S corp. So if you're not a U.S. citizen, you don't have a U.S. citizen or U.S. resident, you're not going to be able to own stock in an S corp. There are also certain, I suppose, regulatory compliances that come up depending on what your company does. We've had transactions recently. If you're dealing with sensitive national security type information, there's going to be limitations as to you might have to gain approval for a foreign-born person buying stock in a United States company. But again, those situations are relatively rare. I think that in terms of the startup world, the thing to consider is probably the limitation on S corp stock ownership.
Okay, and a second question, can an LLC be changed to an S corp? I think you did touch on this, but what are the challenges of doing that?
So you can convert between entities, and it's not uncommon, and it's not too difficult. There are methods of statutory conversion in all states. Massachusetts, certainly, Delaware, New Hampshire. I mean, they all have or typically have a statutory conversion process, which might be filing articles of conversion in the state in which you're currently doing business, or if you're going to change from an LLC, a Massachusetts LLC, to a Delaware C corp because the direction of your business has changed. There's typically a statutory solution in order to get from point A to point B. So it is certainly possible. It is. I think the downfall is that it creates more legal work, but it is not. It's not impossible. Though I think I would encourage, again, at the beginning when you're starting your business, and it's not possible to see every scenario, but if your goal is, certainly to build a business and ultimately go public, it's probably important to consider what type of entity you ultimately want to form, so you don't have to go through the hassle of converting your business from an LLC to an S corp or C corp or what have you.
Okay, and here's another question. Is the piercing of the veil that you mentioned also a potential concern for a C corp?
Yes. So to clarify, it's a concern for LLCs, S corp, C corps. It's a concern for all entities that offer the limited liability, or the liability protection. The idea is that if you are running a business properly, the business is a separate person, and the business therefore is responsible for any harm that might happen to somebody else. If you are not running the business properly, you're intermingling funds, you've undercapitalized your business, and the business begins to look more like your personal bank account, a court is going to be more likely to say, you know what, you have not maintained your corporate formality, you've not operated this business properly, and we feel that the corporation is really more your alter ego, and you're going to be subject to personal liability, and you're not going to get that benefit from the corporation or the LLC of limited liability.
Okay, thank you. One more question. What type of business insurance do I need to consider? You mentioned business insurance at the end there.
Yeah, I mean, I guess it depends on what kind of business you have. Obviously, if you own real estate, you want commercial insurance. If you might want officers and directors insurance. So I guess it depends on what kind of business you're running. So if you do own real estate, you want to make sure someone's covered if they slip and fall. And I think you might want to make sure that you have officers and directors insurance as you're sort of involved in running and growing your business as well.
Thanks. Are there any other questions from participants on the call?
Hey, Joan, if I could make one more point here, and this is the organization that you all have is fantastic, and it's New England based, and I'm a Worcester, Massachusetts based lawyer. So if I could just make a personal appeal to those those watching for the city of Worcester and the surrounding regions. I mean, New England's a wonderful place to do business, and I think you'll see that if you look at some articles that are out there. But Worcester in particular, I'm here on a day-to-day basis, and we have a wonderful regional chamber of commerce, which is really supportive, that is working to connect, the higher education, which Worcester is. It's a higher education hub, not unlike Boston. We have a number of, I think we have 9 colleges and universities. They've set up a venture forum, which is sort of puts on programming for entrepreneurs on a monthly basis. We've got the Worcester Clean Tech Incubator. The real estate is more affordable than it is in Boston, but we are still only 45 minutes away from the city. And it is central to doing location-wise in terms of the location on various highways. It is central to all of New England. I mean, you can get southwest, east, and north easily from anywhere in Worcester. So that's my plug for the city of Worcester. And I appreciate you letting me make that.
And we agree. And thank you for pointing that out. Besides Worcester Clean Tech Incubator, we also have MBI, Massachusetts Biomedical Initiatives, as part of our network. So certainly always willing to give them visibility and promote their activities.
Yeah, no, thank you. Yep.
And of course, you're getting the Paw Sox, right?
We are the Woo Sox. It's now officially the Woo Sox. So they are coming, and we are very excited to have them.
Well, kudos to that.
Mm-hmm.
So this concludes our 5th in a series of 5 webinars that we have organized for this year. We're going to be doing 5 more on other topics of interest for international landings. So do watch our website for the schedule of those and for registering. For anyone on the call that is an international startup, we also offer some pre-landing programs for international startups that are looking to connect in with the ecosystem here and doing some customized work for you to get you the meetings you need on the ground. So that again is outlined on our website, so do have a look. Other resources that we have on our website are a technology ecosystem asset map, where you can do some filtering and see what kind of assets are available for your type of company here, as well as a resources page with a lot of other information about sort of doing business. Who are the players here? What are the opportunities in the state with different organizations, funding opportunities? Lots of information on our website, so I do hope you will have a good look at that. So thank you for joining us today, and we hope you'll join us again soon.